Many of you will be shocked about how much the government and gun control crowds are lying to you about suppressors, aka silencers, and how both are trying to have their cake and eat it too. Of course, others of you won't be very surprised at all. Both ways, that ends now. I'm going to be exposing their viral weaknesses while we dip into why suppressors are protected by the Second Amendment, as well as how the Fourth Circuit Court of Appeals respectfully got a recent decision wrong in U.S. versus Saleem. We're going to be touching on that here. The hair splitting that the anti-gunners are engaging in will determine the future of the Second Amendment, big picture. And these are immediate legal battle issues that you can see fought in this case. You need to know this, even if you do not care about suppressors, because it will affect you. I'll be highlighting the hows and whys. So guys, let's get into it. All right, so here's a fast roadmap. We're going to talk a little bit about the case, but I'm not going to be boring you on the case because the case is really just kind of the appetizer to the entree of the suppressor issue. We're going to be talking about the two sides of the case first and super briefly short barrel shotguns before pushing into the main course suppressors, aka silencers. So for those of you who could not already infer this, Mr. Saleem was caught with both a short barrel shotgun as well as a suppressor. He wound up being convicted and sentenced by the Western District Court, so it's a federal trial court, the Western District Court in North Carolina, to 18 months of incarceration for being in possession of both. On appeal, the Fourth Circuit Court basically shot down, so they wound up upholding the convictions and ruling against short barrel shotguns and suppressors, but for entirely different reasons. And again, you're going to stick around for this. There's something that's going to make your blood boil. So really quickly, on the short barrel shotgun thing, they basically said, look, we've got this 1939 case from the United States Supreme Court, U.S. versus Miller. And then, of course, both Heller as well as Brune both incorporated that and more or less baptized it into the current lineage of Second Amendment history. Therefore, short barrel shotguns, no good. That's the really short version because, frankly, if you check out the attached brief as far as how the court decided the case in the description box below, they really were that short. Now, I did a two-part video series about the whole crazy, insane background to Miller, about the fact that he was effectively chopped up and dead. His attorney had they didn't even copy the briefs when this is all going on. Assuming you want to even count him as an attorney, only the government's attorneys were present at all arguments for the United States Supreme Court. There's no counter. I can keep going on and on and on. Crazy case, but it continues to follow us to this day. So part one is the whole background. Part two is then the legal decision itself and moving through. Both of those will hopefully be popping up somewhere on your screen so you can check that out, as well as at the end of this video and of course linked in the description box below. But basically they just said, hey, Miller, Heller, done on the short barrel shotgun. So are we. Hey, really quickly, two things. Number one, if you're enjoying this video, of course, all the YouTube things, please consider giving it a thumbs up. Number two, we've got a sponsor for this video, and that's my law firm. It takes me, I think, as you can guess, a fair amount of time to research for these videos, put them together, come and film them, all that kind of good stuff. Not to mention Derek, our brave videographer and editor, who is, of course, working full-time for the law firm to come in and do all that kind of good stuff as well. So something you can do if you're enjoying our legal education content is please consider giving our Google My Business page for the law firm a 5-star review. It's something that really helps out the practice, which at the end of the day allows me to come here and play internet lawyer for you. So it's absolutely free, takes a few moments. Just check it out in the pinned comment below. It's also in the description box. Follow the link. It asks you to rate us on 0 to 5 stars. Keep in mind, this is the internet. 3, 4 stars, kind of a failing grade. So if you felt like you get good, decent legal education content, please consider leaving a 5-star review. I appreciate it very, very much. Now back to the program. All right, suppressors, why you clicked. This is going to be interesting. 3 points. Starting the first point, there's no precedent to cite here for the United States Supreme Court. The U.S. Supreme Court has never handled the question of whether or not suppressors are protected by the Second Amendment. There's no ordinary common use analysis. There's no history and tradition analysis. There's none of that kind of stuff here. We're starting from virtually, I say virtually because there's a couple things, but virtually a clean, clear slate. They cannot press the easy button like on short barrel shotguns and just scooch it off to the side. And again, more analysis than that in those Miller case videos that I did. Also, what I think is notable is the fact that what the court did not do is go down the common use test. There are pushing 5 million suppressors in the United States right now. 5 million. And more important than that, than the actual number, is the fact that we are stacking suppressors really fast. Wild growth. You give yourself a pat on the back, all right? Then go buy another suppressor. Not sponsored by a suppressor company. But you get the idea here. We're going to be going into those numbers because they will be relevant a little later on. But I thought it was really interesting in reading the decision what they did not notice and go into. What they did go into is kind of the standard anti-gun, pro-government, all that kind of stuff of saying, look, I can operate a firearm without a suppressor. Therefore, a suppressor is not essential to the use of the firearm. And since it's not essential to the use of the firearm, it's an accoutrement. It's an accessory. It's not covered by the Second Amendment. That's the basic formula that you keep seeing anti-gunners try to make. Here's one of my big points to you about this. This may seem like some sort of sideshow that a lot of you are going to say, I don't care about suppressors. I don't care about silencers. I don't care, okay? Mark my words. At some point in the future, anti-gunners will use the exact same argument that they are using here with suppressors and previously, as well as right now, with magazines for handguns and rifles and so forth, to outlaw things like scopes, slings, bulletproof vests, all sorts of other stuff. This is a major battle line. What does the Second Amendment cover? How many hairs, how far can the antis whittle this down, in essence? Now, you need to understand what Heller was getting at. Heller was the case back in 2008, United States Supreme Court, DC versus Heller, which really set the table for so many things here to come. Among the things that it did is it defined what is an arm, defined all these things, lined out common use, you name it. Heller was putting the reader, that's you, that's me, in the seat of people who answered the call back on April 19th, 1775, the morning of the battles of Lexington and Concord, when the men in those towns answered the muster call to defend their liberty. What did they bring with them? Because condensing Heller, that's in essence how they are answering the question of what does the Second Amendment cover? Those sorts of arms, the sorts that ordinary people had access to, owned, and would respond to such a call to protect their freedom, those are the arms and the exact type of bearable arms that the Supreme Court ruled in Heller are protected by the Second Amendment. Now, as I mentioned before, there are about 5 million and growing fast suppressors across the United States. Now, this is all despite the fact that 8 states ban their purchase and possession, including California, Delaware, Hawaii, Illinois, Massachusetts, New Jersey, New York, and Rhode Island, and of course, for good measure, the District of Columbia. When I said growing fast, according to a Freedom of Information Act request, there were about 830,000 new suppressor purchases between May of 2021 and January of 2024. That's about 32 months where we chalked up just short of 26,000 suppressors per month. Now, numbers without context are meaningless. So let me give you some context to interpret and understand these numbers. Glocks are some of the most popular handguns in the entire world. I think they are the most popular handguns in the entire world. Glocks control, you Google, you get different answers, so don't nitpick me on this, but it's something approximating 2/3 of the US law enforcement and civilian market, according to the interwebs. And we know the interwebs, they're never wrong. An article linked in the description box below estimated Glock sales to be about 1 million Glocks are sold in the United States each year. That's about 80,000 Glocks sold per month. So this would mean that suppressors at 26,000 per month are by far and away one of the largest types of handguns, if they were handguns, sold and purchased in the United States over the last few years. Now, there's lots of ways to nitpick this. I understand that. But this further goes to underscore 2 points. 1, they aren't in common use yet, maybe, but they will be soon. 2, they are absolutely something that people would bring with them to muster. If April 19th, 1775 happened in 2024, 2028, 2042, you name it. So then there's another interesting point. And this is kind of that bonus one that I teased before. So there's this whole anti-gun reply that basically says, look, silencers are literally not firearms. They're literally not guns. So what are we doing saying they're protected by the Second Amendment? Even though the Second Amendment did not say firearms, they said arms. Arms is a much larger category, right? Well, the interesting thing about that is silencers, if you're in court, they actually can and are a gun. You see, Section 18 U.S.C. 921, sub A, sub 3, defines, in the description box below, a firearm as including, sub C, any firearm muffler or firearm silencer. So this is kind of like, a Aikido or something. This is using the enemy's energy against them. All right, you want to regulate silencers like firearms? All right, you can do that, I guess. We can't stop you yet, although we're working on it. But let's set this up. That means first anti-gunners declare silencers to be firearm. This triggers a whole raft of laws that involve sale, transportation, carry, and all these nasty both federal, state, and local criminal codes that encumber law-abiding citizens who just want to shoot guns, not go deaf, and stay out of prison that we all have to follow. Because, hey, that thing that, in court we're told this is not a gun, well, unless you're trying to carry it, buy it, sell it, transport it, or something like that, right? Or maybe carry it into school, because then suddenly it's a gun. So it's only a gun when it's inconvenient for us, and it's only not a gun when it's favorable to them. Does this not sound like heads I win, tails you lose to me? At the end of the day, the anti-gunners need to pick a lane. Otherwise, I suspect a court will soon pick it for them. Are silencers going to be a gun, or are they not going to be a gun? We've got common use now or soon. We've got the whole muster issue here. That's number 2, of whether or not suppressors would be something that people responding to a threat to their liberty would be bringing with them as a bearable arm at that point in time. And of course, last but not least, you can't have it both ways to harm Americans. You can't use silencers as guns against us in criminal courts and then say that they aren't when it comes to the Second Amendment. That seems a little too ridiculous, even for Washington, D.C. I appreciate you sticking around. Hit that like button. Let's get to our ever popular quote of the day. This one comes from St. George Tucker from Blackstone's Commentaries on the Laws of England. Foundational document. I think it was the second most purchased and read book by our founding fathers. Outside, I think Montesquieu is number 1. Quote, "This may be considered as the true palladium of liberty. The right of self-defense is the first law of nature. In most governments, it has been the study of rulers to confine this right within the narrowest limits possible. Wherever standing armies are kept up, and the right of the people to keep and bear arms is, under any color or pretext whatsoever, prohibited, liberty, if not already annihilated, is on the brink of destruction." In other words, the more that governments try to prohibit firearms, and they inevitably do, this is 1803 is where this particular quote's sourced from, liberty and the destruction of it will inevitably follow. I appreciate you sticking around, and I'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.